Executive Council to the Delta State Civil Service Commission to downgrade him by one step is therefore ultra-vires the powers of the Council. Claims for 6 other reliefs are as follows: a declaration that the directive of the State Executive Council to the Delta State Civil Service Commission to demote the claimant by one salary grade level is ultra-vires, unlawful, and a breach of fair hearing. 2, a declaration that the claimant is a grade level 14 staff of the Delta State Civil Service Commission at the material time relevant to this suit. An order setting aside the decision of the Delta State Executive Council to demote the claimant by one salary grade level. D, an order of court directing the defendants to effect claimant's promotion from grade level 14 to grade level 15, excuse me, effective on 1st January 2019. E, 1 million as cost of litigation. F, perpetual injunction restraining the defendants from taking further steps towards implementing the decision to demote claimant. Given relief A of the claimant, the contention of the claimant is that the power of discipline of civil servants in Delta State is vested in the Delta State Civil Service Commission and not the Delta State Executive Council. The argument of the claimant here is that he was never invited or requested to appear before the investigative committee set up by the Delta State government to look into issues of alleged irregularities in the Delta State government payroll. That a few persons from the office of the SSA ICT were invited by the committee for inquiries and investigation into the alleged irregularities in the Delta State government payroll. That he was never invited or questioned by the committee for any involvement in the alleged irregularities, and his name was never mentioned at the material time as a person of interest or a party to whatever investigation or inquiries that was carried out by the committee. That the committee came up with a report after investigation, and he was never mentioned in the report. The claimant continued that he later received a verbal invitation through phone call from the appraiser committee only as a staff who had worked in the said office of the senior special assistant on ICT for the clarification of issues. That he was not among the staff under investigation by the committee. That he was never indicted by any of the committee set up to investigate the matter, but merely advised by the appraiser committee to be more vigilant and was told to go. That the Delta State Executive, on receipt of the committee report, directed the fourth defendant to demote the claimant by one salary grade level without any reason whatsoever, instead of accepting the findings of the committee. In reaction, the defendants maintained that the demotion of the claimant was not illegal, as due process was observed, and the Executive Council of Delta State acted within their powers when they directed the Civil Service Commission to take disciplinary action against the claimant for his role in the matter of unlawful inclusion of names into the state payroll. That the Civil Service Commission, in a letter with reference number PPE 152/T/54, dated 8th May 2018, demoted the claimant by 1 grade level. That it is tried law that by granting what has not been prayed for, going by claimant's relief 30B of claimant's statement of facts, a court suo motu gratuitously awarding a remedy and pleaded will be in error. Cited Mwokoro and others versus Omuma and another. The citation is in the judgment. Relief 30B of the claimant's statement of facts seeks the court's declaration that the directive of the State Executive Council to the Delta State Civil Service Commission to demote claimant by 1 salary grade level is ultra-virus, unlawful, and a breach of fair hearing. Paragraphs 1 and 20 of his statement of facts, the claimant averred that the fourth defendant, on receipt of the directive of the State Executive Council, then went ahead and erroneously demoted claimant from salary grade level 13 to grade level 12, whereas the claimant is a salary grade level 14 officer at the material time. That the State Executive Council has no power whatsoever to direct the fourth defendant to demote him. In Sterling Bank PLC versus Katagun Enterprises Limited, the Court of Appeal heard Pel Iyizoba JCA does. I'm quoting. In any case, the Supreme Court in Ishola versus UBN Limited, citation supplied, per Cargo JS, heard that a relief sought by a party to the suit does not constitute part of the facts in the pleading, and it cannot be granted unless there are facts in the party's pleadings in support of it, upon which evidence can be called. Exhibit CW9, which is the letter of claimant's demotion by the Delta State Head of Service, was not discussed or objected to by the counsel to defendants in final address. The diatribe of defendant's counsel on unpleaded facts is untenable and is accordingly discontinued. On report of administrative tribunal and the role of the executive branch of government, the Court of Appeal heard in Honorable Justice Garba Abdullahi versus the Executive Governor of Kano State and others, per O.G. Abadua, JCA, does. I'm quoting Justice O.G. Abadua. Regarding the contention of the appellant that he was not shown a copy of the recommendation of the three-man committee, it needs to be stated that it is not an established law that the appellant ought to have been invited the second time to be shown the recommendation of the said three-man committee. Military governor versus Wawa Supra, Igu JSC said, there is also the suggestion that it was obligatory on the state government to invite the respondent for another round of defense after it received the panel's report, but before publishing its decision thereupon. Again, with respect, I cannot accept that the Imo State Executive Council was duty-bound to invite the respondent a second time for the presentation of his case all over again, or that failure by government to invite him for the purpose of foresaid invalidated the decisions of the military governor on the inquiry recommendations. In the present case, the Imo State government, following allegations of grave misconduct against the respondent, set up an administrative board of inquiry, which duly sat, investigated, and submitted its recommendations to government. The respondent fully put his case across to the panel at the investigation, at the conclusion of which exercise, the panel submitted its report to government. I think I ought to observe that the report of the panel or the administrative board of inquiry in the present case was nothing but mere recommendations to government and not decisions. It was the duty of the government, having studied and deliberated on the report, to take its final decision thereupon. The proceedings of the panel fully show the entire evidence with the respective cases and arguments of the parties concerned. They also reflect all the memoranda and exhibits submitted at the inquiry, and I cannot accept that it is mandatory on the Imo State Executive Council to invite the respondent for his comment on either the panel's report or the white paper on it before the military governor's decision on the matter can be valid. On the evidence, the respondent fully knew the grave acts of misconduct leveled against him and made the fullest use of the opportunity offered him to defend his actions before the panel. In my view, the respondent, having fully presented his case before the panel with the assistance of counsel, was not by law entitled to be invited a second time for another round of defense before the military governor could validly make public his decisions on the panel's findings and recommendations. Close of quote. The case of Wawa Supra clearly demolished and shut out the argument of the appellant that the report of the three-man committee was not brought to his notice so as to give him the opportunity to challenge the same. The same is hereby not countenanced. Close of quote of the case I cited. By the authority of Honorable Justice Garba Abdullahi and the Executive Governor of Kano State and others, Supra, it is axiomatic that the Delta State Executive Council has the virus to discipline civil servants in the Delta State government. I so hold. Relief A of the claimant cannot accordingly be granted. It is hereby dismissed. Relief B is a claim for a declaration that the directive of the State Executive Council to the Delta State Civil Service Commission to demote the claimant by one salary grade level, that is from grade level 13 to grade level 12, as stated in the letter of demotion dated 8th May 2018, is ultra-virus, unlawful, and a breach of fair hearing. It is the claimant's contention that he was never issued any query, neither was he given the opportunity to defend himself before the decision to demote him by one salary grade level, that the fourth defendant, on receipt of the directive of the State Executive Council, then went ahead and erroneously demoted him from grade level 13 to 12, whereas he was a grade level 14 officer at the material time. That the State Executive Council has no power to direct the fourth defendant to demote him, that due process was not followed by the defendants. In reaction, the defendants maintained that the claimant was not illegally demoted as due process was observed, and that the Executive Council of Delta State acted within its powers in directing the Civil Service Commission to take disciplinary action against the claimant for his role in the matter of unlawful inclusion of names into the state payroll. Demotion at law occurs where an employer unilaterally alters an employee's contract of employment in circumstances where the employer has no contractual entitlement to do so. The change of the employment contract may include a change to a lower graded position or lower level duties, or a reduction in remuneration. There is a citation in the judgment. That is ashhot.com, assessed on 25th July 2022. Demotions are most common in the context of poor performance, misconduct, and restructuring, and redundancies. In these situations, demotion is often a deliberate alternative to dismissal. See landaulaw.co.uk, assessed on 25th July 2022. The right to demote an employee falls within the prerogative of the management. On what claimant knew about the unauthorized inclusion of names from Ugwashiku Polytechnic in the payroll of which the claimant was a beneficiary, he answered at page 22 of Exhibit DW2, that is the appraiser report, that he, and I'm quoting him, he was aware of the issue but did not know it was illegal, close of quote. The committee to investigate the alleged unauthorized inclusion of names and other irregularities in the payrolls of Ugwuchukwu et al. Was constituted by letter number AG/BE/C/86/C/Vol2/T/7 of 26 August 2015. That's Annexure A. The said letter emanated from the office of the head of service, Governor's Office, PMB 5001, Asaba, Delta State of Nigeria. The head of service who performs his duties under the auspices of the Governor's Office, it stands to reason that the report of investigation and recommendations made, in my humble view, must be submitted to the governor for further action, and I so hold. By the authority of military governor of Imo State and Mwawa, the citation is in the judgment, the Delta State Government Executive Council had the virus to consider the investigation and appraisal report and direct the Delta State Civil Service Commission to take appropriate action against the claimant, and I so hold. Relief B of the claimant cannot accordingly be granted. It is hereby dismissed. Relief C seeks the court's declaration that the claimant is a grade level 14 staff of the Delta State Civil Service Commission at the material time relevant to this suit. It is the claimant's argument that he was employed by the Delta State Civil Service Commission on 15th April 2002, see Exhibit CW1, that at the time of filing this suit, he was a salary grade level 14 officer, see Exhibit CW6, that he was wrongly referred to as a level 13 officer, hence the decision to demote him from level 13 to level 12. See Exhibit CW9. The defendants would, however, state in paragraph 6, sub 2 of their statement of defense that the promotion of the claimant to Chief Administrative Officer, salary grade level 14, was done in error, as the claimant was already under disciplinary action and therefore not qualified to be considered for any promotion. Hence, the claimant's demotion from salary grade level 13 to salary grade level 12. But as to whether the said promotion to grade level 14 was in error and was in fact withdrawn, the defendant did not say. And the disciplinary action the claimant was already under, the defendant did not state in their pleadings or at all. Exhibit CW5, dated 22nd January 2014, is letter of promotion to the claimant by the head of service, Governor's Office, Asaba, Delta State. It goes thus: promotion. I'm directed to inform you that the Civil Service Commission has, by its letter number S79/A, volume 3/171, of 11th December 2013 approved your promotion from the post of Principal Administrative Officer, salary grade level 12, to that of Assistant Chief Administrative Officer, salary grade level 13, with effect from 1st January 2013. PC Kencho, Permanent Secretary for Head of Service. Exhibit CW6, dated 25th January 2017, is the letter of promotion to the claimant from the Head of Service, Governor's Office, Asaba Delta State. It states thus: promotion. I'm directed to inform you that the Civil Service Commission has, by its letter number S.79, volume 7/468, dated 16th January 2017, approved your promotion from the post of Assistant Chief Admin Officer, salary grade level 13, to that of Chief Admin Officer, salary grade level 14, with effect from 1st January 2016. Please accept our hearty congratulations. F.O. Isume, Permanent Secretary for Head of Service. Promotion letters are documents that human resources, that is HR representatives or administrative officers, send to employees after they receive an internal advancement. These letters serve as a formal method of communication between an organization and the employee receiving a promotion. Typically, promotion letters outline the extent of an employee's new role, including job title, responsibilities, and expectations. Expected start date and terms of employment, reporting manager or head of department / unit, and structure of position, compensation and benefits, bonuses, raises, and an invitation for clarification. Promotion letters are important because they serve as an official method of correspondence between an organization and the employee receiving an offer for their advancement. The letter also helped establish a shared understanding between an employer and employee regarding promotion scope. Exhibit CW9, dated 8th May 2018, is a letter from the head of service to the claimant. It reads thus: report of the Committee on alleged unauthorized inclusion of names and other irregularities in the payroll of Ugwashiku and Ozoro Polytechnic State Universal Basic Education Board. Sequel to your involvement in the unauthorized inclusion of names and other irregularities in the above mentioned establishment, I am directed to inform you that the Civil Service Commission has, by its letter number S60/83 of March, approved your demotion from the post of Assistant Chief Admin Officer, salary grade level 13, to that of Principal Admin Officer, salary grade level 12, with effect from 10th January 2018. Please be informed accordingly. P.I. Ojeblenu for head of service. The defendants had stated in paragraph 6, sub 1 and 2 of their statement of defense that the Civil Service Commission, in a letter with reference number PPE .1152/T/54, dated 8th May 2018, demoted the claimant by 1 salary grade level. It is tried law that if any disciplinary action is to be taken pursuant to any statute, law, or rule, there must be full compliance with them or any of them as required before such disciplinary action can be properly based or justified. See Iderima versus Rivers State Civil Service Commission. The citation is in the judgment, and that is a Supreme Court decision. Having investigated the claimant and not found culpable by the investigation panel, and the review panel, the defendants are obliged by law to justify his demotion by 2 steps. The claimant, in the circumstances, ought to be granted fair hearing. See Institute of Health, Ahmadu Bello University Teaching Hospital Management Board versus Mrs. Jume R.I. Audi Anyip, R.I. Anyip. Citation is in the judgment. And by Udegbunam versus Federal Capital Development Authority and others. The Apex Court held that an employer has a discretion to give lesser punishment to an employee, but it has no discretion to give a higher punishment. The defendants, in my humble view, went way too far in visiting the claimant with extreme measures by the double demotion, which I dare say is unwarranted. The promotion of an employee is not a trivial exercise. It is sacrosanct. There is no iota of proof in the defendant's averment that the promotion of the claimant to Chief Administrative Officer salary grade level 14 was done in error. It is even an act of self-indictment by the defendants. The defendants cannot approbate and reprobate. The grade level the claimant was on as at 8th May 2018, when the claimant was demoted by 1 salary grade level, is the determinant date. The Indian case of Kishore Shinha versus State of Bihar on the law or principle that order of punishment cannot be passed with retrospective effect, it held thus. The petition challenging the order of reduction in pay scale and stopping of increment was allowed by a single judge Judge bench, comprising of Kumar Shah George. The petitioner, who worked as a junior engineer in the rural construction department, was subjected to an so concluded. The pay of the petitioner was reduced to the lower stage, and his increments were also stopped. The said order, which was passed on 14th October 2006, was set aside by the High Court in an appeal preferred by the petitioner. Thereafter, another order was passed by the respondents dated 31st March 2016, which was in same terms as the earlier order. The order was challenged by the petitioner in the instant petition. The High Court considered the record and found that the impeached order was a violation of the terms of Bihar's service rules, as the order did not provide any time frame for the reduction of pay scale. Further, the order proposed to inflict punishment on the petitioner with a retrospective effect, and that could not be allowed. The court held it to be settled law that an order of punishment can never be retrospective, and it always has to be prospective, not retrospective. Therefore, the court held that the impinged order was liable to be set aside, which was ordered accordingly. The emphasis is mine. The combination of the Civil Service Commission letter of 8th May 2018, demoting the claimant by one salary grade level, and then garnishing his demotion with his promotion to the rank of Chief Administrative Officer, salary grade level 14, dated 25th January 2017, but with effect from 1st January 2016, in my considered view, tantamounts to double jeopardy. By PML Nigeria Limited versus Federal Republic of Nigeria, the doctrine of double jeopardy prohibits a person being tried or punished twice for the same offense with the same set of facts. And this principle is also enshrined as a fundamental right in Nigeria under Section 36(9) and 10 of the 1999 Constitution. Exhibit CW6, dated 25 January 2017, by the evidence before the court, was claimant's promotion from the post of Assistant Chief Admin Officer, salary grade level 13, to that of Chief Admin Officer, salary grade level 14, with effect from 1st January 2016. By Exhibit CW9, dated 8th May 2018, his demotion by one salary grade level should be from the post of Chief Admin Officer, salary grade level 14, to that of Assistant Chief Admin Officer, salary grade level 13, and not from the post of Assistant Chief Admin Officer, salary grade level 13, to that of Principal Admin Officer, salary grade level 12, with effect from 8th May 2018, and I so hold. One other thing, the letter of demotion, that is Exhibit CW9, dated 8th May 2018, taking effect from 10th January 2018, also makes his demotion with retrospective effect. By the provisions of Section 254C1, subsection F of the 1999 Constitution, all of this tantamounts to unfair labor practice, and it is unconstitutional. I so hold. Relief C succeeds and is granted, and I so hold. Relief D is a claim for an order of court. Setting aside the decision of the Delta State Executive Council to demote the claimant by 1 salary grade level. The grant of Relief D is hinged on the grant of Declaratory Relief B. So Relief B, having failed for lack of proof of same, Relief D is therefore not grantable. It fails and is accordingly dismissed. Relief E is a claim for an order of court directing the defendants to effect the claimant's promotion from salary grade level 14 to grade level 15, effective from 1st January 2019. The defendant does not think that the claimant is entitled to promotion. That promotion is not a right, but a privilege. Cited the case of Nwoye versus FAAN, Supra. Promotion by law, except where vindictiveness or bad faith is shown, is not a right, but a privilege. See Abenga versus Benue Judicial Service Commission, Mrs. Miriam versus University of Ilorin Teaching Hospital Management Board, and another. The citations are in the judgment. This being so, the claimant cannot be heard to have proved his right to promotion to the rank of salary grade level 14 to salary grade level 15, effective 1st January 2019. His claim in that regard must fail and is hereby dismissed. Relief E is for 1 million naira as cost of litigation. The claim for cost is a claim for special damages, which by law must be particularized and proved by concrete evidence. See Yenkarti and another versus Abba and others. See also Olusegun versus Ubanatu. See UBN PLC versus Chimaeze. The claimant, in my candid view, has failed to establish his entitlement to the special damages by credible evidence. Relief E accordingly fails, and so is hereby dismissed. In all, and for the reasons given, the claimant's case succeeds, but only in terms of his relief E, as indicated earlier. Accordingly, I make the following declaration and order. It is hereby declared that the claimant is a grade level 14 staff of the Delta State Civil Service Commission at the material time relevant to this suit. 2, consequently, it is hereby ordered that the demotion of the claimant by 1 grade level is from salary grade level 14 to salary grade level 13, and not from salary grade level 13 to salary grade level 12 as in Exhibit CW9. And same must be appropriately reflected in his record of service by the defendants within 30 days of this judgment. Judgment is entered accordingly, and I make no order as to cause. Right. The next case on the course list is NICN/OK/39/2019, Kenneth Meze and Nnamdi Azikiwe University and another. Appearances in this matter.
With utmost humility, my Lord, my name is
Kenneth Meze, Nnamdi Azikiwe University and another. Appearances.
My Lord, K.O. Nwanna. I humbly appear for the claimant. K.O. Nwanna. N.W.A.N.N.A. For the claimant, my Lord.
Very well. Yes. Any
With
appearance for the
defendants? With deepest respect, my Lord.
Yes.
J.U. Anachose. J.U. Anachose.
Yes.
For the defendants, my Lord.
Okay. This is my judgment. After due consideration of the processes and submissions of the parties, I start off with the defendant's reply on points of law, which was in the main a repetition of the submissions of the defendants already canvassed in their final written address. The reply on points of law is meant to be just what it is. That is a reply on point of law. It is not meant for the party replying on points of law to re-argue its case or bring in points it forgot to advance when it filed its final written address. The reply on points of law is thus not meant to improve on the quality of a written address. See Yanati Petrochemical Limited versus EFCC, Kalu versus the state, Ubom and others versus the Kanu. Daliop versus Madala, Wolabi versus Tejoshu and another, Main Street Bank Registrars Limited versus Permit. In the main, therefore, I shall discountenance the defendants' reply on points of law to the extent of its repeated submissions. In the course of trial, the defendants raised objection to the admissibility of Exhibit CW9 and CW19. Exhibit CW9, dated 20th June 2012, is a letter from claimant solicitors to the first defendant's vice chancellor. It is titled Request for Certified True Copies of Documents. Exhibit DW19, dated 11th December 2012, is a letter from claimant solicitors to first defendant registrars for CTC of documents. Learned counsel to the defendants did not perfect their objection to these two exhibits by the non-inclusion of their grounds of objection to the final written address and response thereto by counsel to claimant. In the circumstance, it stands to reason that counsel to defendants abandoned their objection to exhibits DW9 and DW19. Exhibits DW19 and DW9 are documents, that is notice to produce, prepared by claimant's counsel and served on the defendants. It means then that counsel to claimant would retain a copy of the said notice to produce. By PDP versus ENEC and others, the file copies of the original correspondence addressed from the claimant's counsel to the Vice Chancellor of First Defendant University and the Registrar of First Defendant University should be the ones to be tendered by the claimant's counsel if such a need arose or at all. Order 45, Rules 2, Sub-Rule 2, and 3, Sub-Rule 1 and 2 of this court's rules provides that a written address shall not be more than 35 pages, set out in paragraphs and numbered serially, and shall be concluded with a numbered summary of the points raised by the parties' prayer. That failure to comply with Rules 2 and 3, Sub 1 of the order may render the written address incompetent. Counsel to the defendants does not seem to get it that the word serially used in Rule 2, Sub-Rule 2 applies to each and every page and paragraph of the written address, or that by Rule 3, Sub-Rule 2, failure to comply with Rules 2 and 3, Sub 1 of Order 45 of NICN Rules 2017 may render the written address incompetent, were there no waiver of sanctions but for the interest of justice. Paragraph 7, 8, and 9 of his statement of facts, the claimant averred that a letter reference number NAU/R/45A/volume 7/66 of 18th February 2010, addressed to one Barrister Boniface Meze, purporting to suspend the said Barrister Boniface Meze, was served on the claimant that by a letter reference number SSD/9/10/003 of 25th February 2010, an invitation to appear before the SSDC, that's the Senior Staff Disciplinary Committee, on 3rd and 4th March 2010, addressed to one Barrister Boniface Meze, was served on the claimant. The claimant averred that his name is Kenneth Nzedigwe Meze, and he is so known to the defendants. In reaction, the defendant stated in paragraph 2 of their statement of defense that the claimant was not misled by the name with which he was suspended and invited to appear before the SSDC, which invitation the claimant honored, wherein he presented his own side of the case. In the case of Universal Malting Company Limited and another versus Messrs. Singolds and Company Limited and others, the Court of Appeal heard per Oho JCA, thus, I'm quoting Justice Oho, the test which has been applied by the courts to assist if the title of a party shown on the writ of summons is a misnomer is well settled. One factor that operates on the mind of the recipient of the writ of summons is whether the writ or is not another entity to which the description or the writ might refer. The test is usually the reasonable man's test of some kind, to wit, how will a reasonable person receiving the document take it? If in all circumstances of the case, and looking at the document as a whole, he would say to himself, of course, it must mean me, but they got my name wrong, then there is a case of misnomer. If, on the other hand, he would say, I cannot tell from the document whether they mean me or not, and I shall have to make inquiries, this would have gone beyond the realm of a misnomer. See the cases of Davis versus SB Brothers Limited, Maylafia versus Veritas Insurance, and Nwabweze versus NIPOST. Misnomer is all about mistake as to name and not mistake as to identity or mistake about identity. It is simply a wrong use of a name. In my considered view, the party intended to be suspended and invited to appear before the SSDC in this suit, as rightly explained by the claimant in paragraph 9 of his statement of facts, as Barrister Kenneth Nzedigwe Meze and not Barrister Boniface Meze, as erroneously addressed. Reference to Barrister Kenneth Nzedigwe Meze as Barrister Boniface Meze by the defendants is therefore a misnomer, and I so hold. I now turn to the merit of the claimant's case. Given the relief sought by the claimant, wherein the claimant claimed that the defendants did not give him fair hearing before his appointment was terminated, claimant submitted that the defendants did not follow the law of the country. Cited Section 360 Criminal Code Act, Cap C-38 Laws of the Federation of Nigeria 2004, and their university regulations, Chapter 2, Paragraph 2.1.11 of Exhibit CW 11, Senior Staff Conditions of Service Regulations 13.7, Sub 8, Sub 7 of Chapter 13 of Exhibit CW 11, and Section 17 of the Nnamdi Azikiwe University Act, that's Exhibit CW 10. That this failure breached the claimant's right to fair hearing. Exhibit CW 10, dated 25th November 2010, is the letter that brought the claimant's appointment to an end. It has a subject, letter of termination of appointment, and read thus, quoting, I'm quoting now, Council at its 78th meeting held on Friday, 8th October 2010, deliberated extensively on the case of sexual harassment in which you were indicted. It noted as follows: A, that you were accused of sexually harassing your students. B, you were suspended and the case was before the Senior Staff Disciplinary Committee, where it was found as follows. 1, that you invited your student, one Chizoba Honora, to your private office at Aroma Junction in Oka and made sexual advances to her. 2, there were lots of irregularities in ESM 521 and ESM 522, the courses you taught, due to the fact that you added marks indiscriminately. And 3, there was evidence that 2 other students were equally sexually harassed. Close of quote. Council viewed the offense as a misconduct that warrants termination of appointment. If it thereafter decided that your appointment be terminated in accordance with Chapter 13, Paragraph 6, Sub 1 of the Senior Staff Conditions of Service, your appointment is hereby terminated accordingly with immediate effect. You are required to immediately hand over all the possessions of the department in your custody to your head of department. Signed, Barrister C.C. Okeke, Registrar. What I gather from all of this is that the claimant's employment was not terminated. He was actually dismissed. And the dismissal was with immediate effect. Given that the effective date of the dismissal is same with the date of the letter of dismissal. The law is that once an employee is dismissed, the employer must justify the dismissal. The duty to justify the dismissal of an employee lies on the employer, the defendants in the instant case. The attempt to justify the dismissal is the argument of the defendants that the dismissal of the claimant's employment was as a result of sexual harassment of his students, irregularities in courses taught by the claimant by the indiscriminate addition of marks. Exhibit DW 2/7, dated June 2010, I'll get a date. June 2010, the SSDC report on the trial of 12 staff of first defendants recommended in respect of the claimant's case that claimant should firstly be seriously warned to desist from such acts of gross misconduct. That secondly, claimant be recalled from suspension and forfeit the arrears of his salaries during the suspension period. That he be demoted by 1 rank, assistant lecturer 1, step 1. And he should never teach any course alone. The evidence elicited from witnesses against the claimant by the Investigation/Intelligence Security Department and the SSDC e.g. head of Department Estate Management, Builder P.E. Ogumo, lecturer Mr. Emmanuel Onora, the father of Chizoba Onora, the charitable Chukudi Daniel, and Chief Security Officer of First Defendant University is all hearsay evidence and not the direct evidence of the alleged victim, that is Chizoba Onora, and I so find. A dismissal or termination of appointment based on allegations of hearsay without credible evidence of proof of same cannot stand in law. See Gislord Associates Limited versus Algon. The defendant's justification of the claimant's dismissal based on hearsay is accordingly untenable, and I so hold. In their reply on points of law, the defendants submitted that, as seen in Exhibit DW 2/8, already agreed that the claimant was afforded fair hearing and initially dismissed this suit. That the claimant's case was, however, struck out at the Court of Appeal for the writ not being signed. That the claimant has not placed anything different from the initial case filed by him to enable the court to arrive at a different decision in this. Counsel to the defendants must have contemplated a situation where the suit struck out was released. The law is tried that a striking of an appeal for being incompetent is never and cannot be regarded by the court as amounting to a dismissal. In Chief of Defense Staff and another, this is Modu Alhaji Tija, that is Makama, the citation is there, in the judgment. The Court of Appeal heard per 2 JCA of blessed memory thus: Gafai FJ struck out the suit without foreclosing the rights of the respondent from relisting same. The respondent could have applied for its reinstatement or could have filed another suit claiming the same or similar remedies. A suit that was struck out can be relisted on the application of the party that instituted the action. When relisted, it is not a new suit. It is still the old suit. See Kasim versus Herbert. When a suit or an appeal is struck out, it is as if no suit or appeal was ever filed. See Ikeaku versus Mwapa. But such a suit or an appeal can be relisted if the factors that rendered the suit or appeal defective and culminated into its being struck out is or are remedied. Also in HB Nigeria PLC versus Ladijani Nigeria Limited, the court heard as follows: an order striking out a matter gives an opportunity to the party who instituted the action to apply to the court for an order relisting same or to file a fresh action. The emphasis is the judice. And by Laferi Nigeria Limited versus Nile Merchant Bank, the Apex Court had enunciated that, I'm quoting the Supreme Court now, although an order striking out an appeal has for some purposes much the same effect as an order dismissing it, it does not thereby become a decision on the merits and does not necessarily preclude a subsequent decision on the merit if the matter can be reopened by an appropriate procedure. In the instant case, the defendants are somewhat different from those in suit number NICN EN/31/2011, the judgment of which was delivered on 30th September 2011. Whereas the claimant in suit number NICN/EN/31/2011 and NICN/OCA/39/2019 is one and the same Kenneth Nzedigwe Meze. The defendants in suit number NICN/EN/31/2011 are Professor Boniface Egboka, Vice Chancellor, Nnamdi Azikiwe University, Professor Reverend Ben Chuks Okeke, DVC Administration, Nnamdi Azikiwe University, Barrister C.C. Okeke, Registrar, Nnamdi Azikiwe University, Nnamdi Azikiwe University, and Governing Council, Nnamdi Azikiwe University. In suit number NICN OCA/39/2019, the defendants are Nnamdi Azikiwe University and the Governing Council, Nnamdi Azikiwe University. The reliefs sought in both suits and the pleadings are, however, substantially the same. The course of action is the factual situation disclosed by the facts in the claimant's pleadings, on which he relies to support the claim made that must be recognized as giving him the right capable of being claimed against the defendants for a remedy or a relief in court. See Sigu Oil Limited versus Moni Pulo Limited. The submissions of the claimant that any allegation of sexual harassment is criminal in nature and that there is no evidence from the defendant on whom the onus is to prove such evidence that there was any court criminal trial of the claimant prior to the punishment meted out on him represents the old learning. The Supreme Court in Arinze versus FBN Limited, citation is in the judgment, heard that an employer can dismiss an employee where the accusation against such employee is of gross misconduct involving dishonesty bordering on criminality. And in such a case, it is not necessary nor required under Section 36 sub 1 of the 1999 Constitution that an employee must first be tried in a court of law. To the court, it is therefore erroneous to contend that once crime is detected, the employer cannot dismiss the employee unless he is tried and convicted first. See also Olariwaju versus Afribank Nigeria PLC. ATA Poly versus Maina, and UBN versus Chinyel. And by Jibril versus Military Admin Kwara State, where there has been admission of commission of misconduct or crime by an employee, the need for proof before a regular criminal court no longer arises. I do not accordingly agree with the argument of the claimant here that before he can be dismissed by the defendants on an allegation of crime, the allegation must be proved in the criminal case before the dismissal can stand. That argument is accordingly discountenanced. Whether the dismissal can stand is another matter to be determined altogether. Exhibit DW2/3, dated 4th March 2010, is the second meeting of the Senior Staff Disciplinary Committee of the First Defendant University. In respect of the case of alleged sexual harassment against the claimant, this is what the Chief Security Officer had to say. We got a telephone message, I'm quoting the CSO now. We got a telephone message that did not give us her name, that Meze used her in his office at Aroma and has been doing it with girls in her class, and you have to do it before you pass. He teaches 3 strategic courses in estate management. We got a girl that confirmed that Meze called her for sex in order to pass the 2 courses he has continued to fail her. We called Meze, he denied it. We went to the department, talked to the HOD, lecturers, and even students that confirmed it. One lecturer said that same girl came and reported it to him in his office, and she went to the HOD to report it. That HOD confirmed it. Chizoba Honora, that is pregnant, has a detailed statement and sent through DHL to us and mentioned names. She called for some scripts. We called for some scripts and saw that what the girl said is true. We invited him again and he denied everything. When VC saw the overwhelming evidence, he suspended him and sent him to this panel. I will send the scripts to you. Close of quote of the SCO, CSO. So what transpired was that SSDC, do you have devices to help you in your work? The CEO said, I don't have any device. The SSDC interviewed the claimant on a case of sexual harassment in which one Chizoba Honora was mentioned and a text message. The claimant stated that he knew Chizoba, Egbe, Uzoma Kalista, and Orizu Uchenna, that he did not call for a meeting of the department board, that he did not forge anything, that he would contest any charge on change of scores, that he made a particular scheme for all of them, that he did not make sexual advances to Chizoba to get materials from Mr. that she failed, Chizoba failed this exam, and the scores can be looked at. That claimant will attribute her failure to the fact that she did not attend lectures. Claimant admitted knowing Chizoba's father, that he came to claimant's private office and said the daughter must pass, that she failed claimant's course and failed other courses, that the attempt was to intimidate him, that is claimant, that they thought his weakness is women. Claimant went on that Honora did not meet him alone at his office at Aroma, that he was not sure Chizoba sent a text message to him, that he was surprised that out of the 6 lecturers that she failed their courses, he was the only one Nora accused, that he did not know why in a class of about 100, the attendance register the claimant had showed 26, some 8, etc. The information that formed the basis of defendant's case against the claimant is the DHL mail sent by Chizoba Honora to the Investigation/Intelligence Security Department, from which the CSO testified before the SSDC. The law is established by EcoBank Nigeria PLC versus Ekperike, that, citation is in the judgment, that no assertion offered as testimony can be received unless it is or has been open to test. by cross-examination or an opportunity for cross-examination, except as provided otherwise by the rules of evidence, by court rules, or by statute. The chief reasons for the rule are that out-of-court statements amounting to hearsay are not made under oath and are not subject to cross-examination. The maker of the statement by law should have been called to testify and be subjected to cross-examination. See Ojukwu versus Governor of Lagos State. See also Agunume versus Eze, in which the Court of Appeal, per Onu JCA, as he then was, heard at page 254 that, I quote, "It is settled law that documentary evidence can only be tendered through its maker." See Opolo versus the state. See Okpara versus FRN. See also section 90 sub 1A of the Evidence Act. Close of quote. Mere reliance on the ipse dixit of Chizoba Honora via her DHL message to the defendants, which was an out-of-court statement without deposition and without availing herself for cross-examination as required by law, fundamentally snuffed out its evidential value and breached the claimant's right to fair hearing, and I so hold. See also Effiong versus the state. The citations are all in the judgment. There is no doubt that the employment of the claimant is one that has statutory flavor. The law is that the procedure for discipline in an employment with statutory flavor must be complied with. Otherwise, the dismissal and suing thereof will be null and void. See Longe versus FBN PLC. Sorry, Longe versus FBN PLC, for instance, heard that in the event of termination of employment with statutory flavor, strict adherence must be had to the statute creating the employment, for statutory provisions cannot be waived. And by Oloruntoba, Uju and others versus Abdurrahim and others, in the matter of discipline of an employee whose employment has statutory flavor, the procedure laid down by such statute must be fully complied with. If not, any decision affecting the right or reputation or tenure of office of the employee will be declared null and void. Close of quote. The question that presently arises is whether defendants complied with the disciplinary procedure under Chapter 13, Sub 7 of the First Defendant Senior Staff Conditions of Service and Section 17, Sub 1 of the Nnamdi Azikiwe University Act. The answer is certainly in the negative, as the claimant showed. I carefully read through the evidence before the court. What I found is that contrary to Chapter 13, Sub 7 of the Senior Staff Conditions of Service and Section 17, Sub 1A and B of the Nnamdi Azikiwe University Act, the first defendant did not, A, give notice of the reasons to the claimant for believing that the claimant should be removed from his office or employment on the ground of misconduct. B, afford the claimant an opportunity of making representation in person. It is pertinent to point out that the claimant's obligation to convoke a joint committee of the Council and the Senate to investigate the claimant's matter, or for a committee of Senate to investigate the claimant's matter, as stipulated in Section 17(1) Sub C of the Act, is wholly dependent on the Council, that is the second defendant, to obligatorily give notice of the reasons to remove the claimant. The word "and" between Section 17 Sub 1A, B, and C means that A and B must be activated by second defendant first before subsection C, 1, 2, and 3 will be implemented by the Council. Failure to do so by second defendant to a priori evoke or activate the provisions of Section 17, Sub 1A and B of Nnamdi Azikiwe University Act robbed the claimant of fair hearing before the second defendant under Section 7(1)(e) Sub 1 to 3 of the Act. And by implication, it also robbed the second defendant of the virus to dismiss the claimant as the condition precedent was not met. C. Shelling and another versus Goban. The citation is in the judgment. In Mr. M.A. Chiroma versus Forte Oil PLC, this court heard at paragraph 38 as follows. I'm quoting. The defendant cannot charge the claimant for dereliction of duty and then turn around much later to say the charge included allowing of perpetration of corruption, of corrupt practice, or corruption by order. The defendant cannot charge the claimant for one infraction, ask him to respond to the infraction, and then find him guilty of an infraction he did not ask the claimant to respond to. I so hope, close of quote. In like manner, the defendants cannot invite the claimant to answer to the charge of sexual harassment on the mere ipsa dixit of one Chizoba Nora via a DHL correspondence with defendants without cross-examination by claimant, and rope in two other students who themselves did not lay any charge or allegation against claimant whatsoever, and tried claimant for irregularities in 2 courses he taught by adding marks to Abba Solomon, Uzoma Kalista, Egbe Ruth, and Orizu Uchenna, whose cases had nothing to do with sexual harassment and who did not lay any such charge against the claimant whatsoever, but which charges were orchestrated by the defendants against the claimant. All of this fundamentally goes against the requirement of fair hearing. One other thing, by Longe versus First Bank of Nigeria PLC, the effect of suspension is that, quote, an employer suspending his employee may impose terms of the suspension, but in a general sense, suspension of an employee from work only means the suspension of the employee from performance of the ordinary duties assigned to him by virtue of his office. Suspension is not a demotion and does not entail a diminution in rank, office, or position. Certainly, it cannot import a diminution of the right or rights of the employee given to him under the law. To accept, as the court below did, that suspension of the plaintiff would deny him the promotion afforded him under Section 266 is to confer the right on the defendant to vary the status of the plaintiff without complying with the procedure laid down for doing so. The defendant cannot first suspend the plaintiff without notice to him of the meeting at which the suspension was discussed and agreed, and then turn around to say that that suspension had removed the necessity to give him the notice as mandatory required under Section 266(1) of CAMA. The court cannot grant to a litigant the right to disobey the law under any artifice or guise, close of quote. Exhibit CW7, dated 6 September 2010, recalling the claimant from suspension, states that management of first defendant approved that claimant be seriously warned to desist from such acts of gross misconduct. And he is so warned that his recall from suspension is with effect from 29th June 2010, that claimant to forfeit arrears of his half salary withheld during the period of claimant suspension, that claimant be demoted to rank from lecturer 2 to assistant lecturer step 1 with effect from 29th June 2010, and that claimant is not to teach any course alone. The law, as stated in Longe versus First Bank of Nigeria PLC, is very clear that suspension is not a demotion and does not entail a diminution in rank, office, or position. Certainly, it cannot import a diminution of the rights of the employee given to him under the law. Close of quote. I do not think that the management of first defendant had the legal right to warn the claimant to desist from such acts of gross misconduct that are still under investigation. The management of first defendant may be unaware of the disciplinary processes involving an employee whose employment is clothed with statutory flavor. Management's premeditated finding of the claimant guilty as charged before his appearance before the SSDC and Council, in my humble view, clearly shows unmitigated and bias against him. All of this tantamount to double or even triple jeopardy, which is not tenable in law, as it connotes the act of being prosecuted, or tried twice, or tried thrice for substantially the same offense. See Nigerian Army versus Brigadier General Maude Aminu Kano, and Abacha versus FRN. The citations are in the judgment. I am accordingly satisfied that the defendants did not strictly adhere to Section 17, Sub 1 of the Nnamdi Azikiwe University Act and Section 13, Sub 7 of the Nnamdi Azikiwe University OCA Senior Staff Conditions of Service before summarily dismissing the claimant from their service. The dismissal is accordingly unlawful and as such null and void. In making this finding by BCC PLC versus AGE, there is no dismissal of the claimant, as what the defendants did is a nullity before the law. Accordingly, reliefs A, B, C, D, E, F, G, H, and I, as claimed, succeed and are hereby granted. I so order. Judgment is entered accordingly. I make no order as to cause.
As the court pleases. Thank you.
As the court pleases. Much obliged, my lord.
Most gentlemen.
Yes. Good. You're welcome. That will be all. The court will rise now.